MCQ. And without wasting the time, I would like to go to the host or Kolikunda, Sharad Babu. You can continue it 1 to 25. Later on that I will come to the rescue, your rescue. Yes, number 1. Proceed. Kolikunda Sharad Babu. Are you hearing me?
Your voice
The
is not
voice,
audible clearly.
voice is weak, sir.
Okay. Because it is just started now. So that's a now it will
Voice
be
not
your
audible.
voice is very much clear. Now you can start. Your voice is very much clear. You start.
Sir, not audible clearly, sir.
See, Kolikonda Sachina, Sarath Babu voice is very clear. You start. Kolikonda, you start it.
The people's good law is the highest law. Cicero.
Go, first
There is a
question.
disturbance in your voice.
Proceed, first question, Kolikonda. I say proceed.
Okay, sir.
Your voice is
The
very
first
clear. Proceed.
question is summary trial does not include one of the following where the offense is. Please scroll up.
Yeah. Proceed.
Scroll up, sir.
No, I already scrolled. You could see my screen.
Summary trial does not include
Your
one of
voice
the
is
following
cracking.
where the offense is A. Option A. Theft of the value of the property stolen does not exceed 2,000 rupees. B. Punishable with imprisonment for a term exceeding 2 years. C. Punishable under Section 454. D. Punishable under Section 465.
Shoot.
Option B.
Yes, option B is the correct answer. Punishable with imprisonment for a term exceeding 2 years. That cannot be under the summary trial. The remaining 3 may be under summary trial. Second question, sir. Scroll up.
Already scrolled.
They are already shot. First question B is the answer, sir. Second question, according to section 266 of CRPC, prison does not include A. Any place which has been declared by the state government to be a subsidiary jail. B. Any reformatory. C. Postal institution or institution of a like nature. D. None of the above.
Option C, postal institution or institution of like.
This problem.
Is it visible for the
Yeah, just a minute, because this I want to close it. It's not closing. Could you see my screen now?
yes?
Yes, sir.
Yes, sir.
Sir, side ko kuti you have to
That's I want to close
One
it.
window is opening unnecessarily.
There is an option to close.
Press escape, sir. If not, try to.
Yes, but that
press
is not
escape.
work. Sir, close is there, but for us
No.
also it is not working.
Escape button will be there on the laptop. Maybe we can try that.
No, even escape also. Generally, when I say close, it will close because purchase subscription, no, get more traffic for
Correct.
free.
Okay, then we
No.
can drag it till the end, sir, so that it will not be visible on the Word document.
Even
So
I
we can
tried
drag
all
it
my permutation
top.
combinations. Let me check it. Whether,
You try
Okay,
first.
continue, sir. Continue.
okay.
Hold that and drag.
Now could you see the three question, third question?
According to section 268 of CRPC, the power to exclude certain persons from operation of section 267 is vested with A, central government, B, state government, C, both A and B, D, Chief Justice of the Supreme Court.
Option
Option A, state government. B, option B, state government.
state government.
Option B, state government is the right answer. Fourth question. The CRPC was created for the first time in option A 1882, option B 1889, option C 1862, option D 1858.
Option 1862.
1882.
Option A is the correct answer, 1882. Next question, sir. Fifth
Yes,
question.
okay.
One of the following is not an ingredient of section 154 of CRPC. A. It is an information which is given to police officer. B. Information must not relate to a cognizable offense. C. It is an information of offense first in point of. It is not visible, sir.
Okay.
Not first in point of time. D. The investigation starts immediately after recording the
FIR.
Option B.
FIR. Yes.
Option D.
Option B is the correct answer. Information must not relate to cognizable offense.
Option B.
Yes, yes, that is the correct answer. Information must not relate to a cognizable offense. Next, sixth question is, a copy of the FIR shall be given to the informant A after collecting a fee of rupees 10 immediately, B after collecting a fee of 10 rupees after 1 hour, C free of cost immediately, D free of cost but after 24 hours.
Option C. Free of cost.
Option C, free of cost.
Immediately.
Yes, option C is the correct answer, free of cost immediately. Seventh question. The information may be given to police officer A by orally to become FIR, option B in writing to become FIR, option C a relevant telephonic information to become FIR, option D any one or all of the above to become FIR.
Option D.
Option B.
Yes,
Writing
option D is the correct answer, any one or all of the above to become FIR. Scroll up, sir. Eighth question. Warrant case is defined by A, section 2W of CRPC, B, section 2X of CRPC, C, section 2Y of CRPC, D, section 2V of CRPC.
2x.
Option B.
2x of CRPC. Option B.
Yes.
Option 2X of CRPC. What is summons case?
Section
2W.
2W.
Yes, section 2W of CRPC. Next, ninth question. Which statement is not true? A. Judicial magistrate shall be subordinate to chief judicial magistrate. B. Chief judicial magistrate shall be subordinate to sessions judge. C. Sessions judge shall not be subordinate to chief judicial magistrate. D. Sessions judge shall be subordinate to chief judicial magistrate.
Option D, sir. Option D.
Yes, option D is the correct answer. Sessions judge shall be subordinate to. Sorry, option B is the correct answer.
Sir, that is which is not wrong.
Is it okay? Section D. Sessions judge shall be subordinate to chief judicial magistrate. Section 15. Is it correct? Please check it. 10th question. Special metropolitan magistrate cannot be appointed for more than A, 2 years at a time, B, 1 year at a time, C, 3 years at a time, D, 1.5 years at a time.
Option B, 1 year at a time.
1 year at a time.
Here at a time.
Yes, option B is the right answer, 1 year at a time. Next, that is section 18 of CRPC. according to. 11th question. The High Court may appoint special metropolitan magistrate, option A, on the request of central government, B, on the request of state government, C, either A or B, D, with its own discretion.
State government.
State
Government.
No state.
Option C is the correct answer,
C,
either
either
A
A or
or B. It can be on the request of central government or on the request of state government also. 12th question. Public prosecutors for High Court shall be appointed by A, central government after consultation with the Supreme Court, B, state government after consultation with the High Court, C, central or state government after consultation with the High Court, D, central or state government after consultation with the Apex Court.
Option C. Option C.
Option B.
B, sir. Should be.
Option
State
C is
government.
the correct
B,
answer,
B.
central or state government after consultation with the High Court.
I go to option B.
It is feedback is there, section 24 of CRPC. Now, 13th question. When any person who in the presence of a police officer has committed or has been accused of committing a dash offense refuses to give his name and residence, or the police officer has reason to believe that he has given false name and residence, the police officer may arrest such person. A, serious, B, heinous, C, non-cognizable, D, cognizable.
Option C, non-cognizable.
Option C, non-cognizable.
This option C is the correct answer, non-cognizable. Section 42 of CRPC. 14th question. The person arrested without warrant shall be informed by the police officer, the group for which he was the cause for which he was arrested, and his right to be released on bail by arranging sureties as per section CRPC section A 51, B 52, C 49, D 50.
51.
50.
Option D.
Option D. 50. Section 50.
Yes, option D is the correct answer, section 50. 15th question. The police officer seeking the medical examination of the accused may
Shravanti,
register
mute.
medical.
Yes, continue.
Police officer seeking the medical examination of the accused by a registered medical practitioner shall be option A, any constable, option B, not below the rank of head constable, C, not below the rank of circle inspector, D, not below the rank of sub inspector.
Option D.
D.
Option
Not below
D.
the rank of the inspector, sub-inspector.
Not below the rank of sub-inspector.
Inspector.
Yes, option D is the correct answer, not below the rank of sub inspector according to section 53. 16th question. A medical practitioner who possesses any medical qualification as defined in clause H of section 2 of Indian Medical Council Act 1956, Act 102 of 1954, and whose name has been entered in a state medical register, it is called option A, physician, option B, physician and surgeon, option C, general physician, option D, registered medical practitioner.
Option D. Registered medical practitioner.
Medical practitioner.
Host, I
Yes.
change it because they know it definitely. They will say that is the registered medical practitioner. That's why I changed it. I made the doctor. The B option is the physician and surgeon, and C option is the PMP, and D option is RMP.
Yes, RMP is the correct
Because they
answer.
thought that RMP means that that man who is having a certificate, RMP certificate, PMP certificates.
Yes, sir. Keeping in that view also, I framed it.
Yeah.
Okay. Your
And they would have
concept
like,
is,
RMP is a acronym or a initialism. Anyone?
Initialism, sir.
Initialism.
Why you are taking so much time to give the answer? Again, this.
yes, sir.
I don't know what is today's matatizo. Huh? I want to scroll it down.
17th question. That's why I am looking at the prepared ones with which I am.
Yeah. And yes, read.
The provisions relating to a summons and warrant and their issue, service and execution shall so far as may be applied to every summons and every warrant of arrest issued under this code are contained as per section 90 of CRPC in the chapter A7, B5, C6, D4. 17th
Chapter
question, sir.
5. Chapter
Sir,
5,
6.
option B.
Chapter 6.
Yes, make it
Chapter
certain.
5.
Option B, sir, 5.
Option C is the correct answer. 6.
No, sir, chapter 5.
In the
Chapter 6.
CRPC,
Chapter 6
just a
is
minute.
correct answer.
I want
Section
to-
90, chapter
it is
6.
rolling down.
Chapter 6.
18th question. The
Yeah,
definition
use
for
your screen.
property in
Let me
CRPC is given in section A 105 AE, B 105 capital A D, C 105 A capital A B, D 105 A.
Screen not visible.
Yeah. Because it is today it is not listening. There is something wrong with the system because I want to drag it. It is going down. Okay, slowly that I will try to. Yeah. See, I want to minimize it first so that you could see clearly. Let me. Is it visible now?
Yes,
Which is the
sir.
question?
Yes.
Which is the question?
18th question, sir.
Yeah. Let me go to the 18th question. Yes, now read. Read.
The definition for property in CRPC is given in section option A 105 AE, option B 105 capital AD, option C 105 capital AB, option D 105 AC.
Option B.
Wrong.
Option
No, it is right.
Option B is the correct answer.
Yes, it is
105
right.
capital A D is the correct answer. Sir.
Yes.
In CRPC also the definition for property is given under section 105 capital A D. 19th question. Acquittal of the accused on the ground of unsoundness of mind is provided in the section dash of CRPC. Option A 333, option B 334, option C 335, option D 337.
Option B 334.
Option A, 333.
Option B is the correct answer, 334. 20th question. The court may, in its discretion, discharge the offender or remit the punishment on his submission to the order or requisition of such court, or on its satisfaction to option A, admission, option B, submission, option C, confession, option D, apology.
It is already there on the screen
Submission.
because I want to drag it down, but it is not coming.
Yes,
Okay,
according to
doesn't
section
matter. It is
348,
apology.
discharge of offender is on submission of apology.
Yes, sir.
21st question. The judgment is delivered in open court by delivering the whole of the A, by delivering the whole of the judgment, or B, by reading out the whole of the judgment, C, by reading out the operative part of the judgment and explaining the substance of the judgment in a language which is understood, capital A, by the convicted or his pleader, B, by the acquitted or his pleader, C, by the accused, D, by the accused or his pleader.
Which question that you read? Is the 21st question?
Yes, sir.
And but where is the other options? Because there are only A, B, C, D is there. And which statement is wrong statement out of the A, B, C, D? Out of the A, B, C, D, which statement is wrong?
Option
Option
A.
D.
I made some modification. That's why you read what I posted on the screen.
Okay, sir. Which of the following is false or wrong? Option A, the judgment in every trial in any criminal court of jurisdiction shall be written in open court by presiding officer immediately after the termination of the trial, some subsequent time of or after some subsequent time of which notice shall be given to parties or their pleaders. B, by delivering the whole of the judgment. C, by reading out the whole of the judgment. D, by reading out the operative part of the judgment and explaining the substance of the judgment in a language which is understood by the accused or his pleader.
Find
Or
out
his
the
pleader.
wrong statement.
It is false. Option D is false.
Option
Option D. D.
wrong. Option A is the wrong statement. The reason is the judgment in every trial in any criminal court of original jurisdiction shall be written, no, pronounced, shall be pronounced in open court by the presiding officer immediately after the termination of the trial or at some subsequent time of which notice shall be given to the parties to their pleader. That is the right. See the feedback. I changed pronounced into the written, which I highlighted in red color. Is it clear?
Clear, sir.
Yes, sir.
Okay, now read the 22nd question.
My concept of giving is till the judgment is delivered, one is the accused, neither acquitted nor convicted.
Because I found something missing over there, that's why I
No, sir.
changed that. Your
Option
question.
D, I have given option D.
Yeah, I changed the question.
Let me read it. Let me read it, sir.
What? Because I changed the question because it made me the confusion.
I will read the same question, sir. The judgment is delivered.
Anyway,
in
doesn't
open
matter.
court.
Doesn't matter. Proceed to 22nd question.
Yes, yes.
Doesn't matter. Huh?
If it be a judgment of acquittal, the judgment shall state the dash of which the accused is acquitted and direct that he be set at liberty. Option A, crime. Option B, offense. Option C, either A or B. Option D, act.
Option A.
None of the
Option
above.
B is
Option
the
D.
correct answer. Offense. Offense is the correct answer. Option B, offense. Actually, crime is not defined, only offense is defined. Section 354 CRPC. 23rd question. When any person is convicted of any offense for having caused the death of another person or having acquitted the commission of such an offense, the persons who are entitled to recover damages from the person sentenced for the loss resulting to them from such death is under A, the Fatal Accidents Act 1854.
I did not keep it there.
1988.
I did not keep it on the. You read what I kept it there on the screen.
A, ME Act 1988, B, ME Act 1938, C, ME Act 1914, D, none of the above.
The above.
Yes, answer.
Option D. None of the above.
What is the right answer?
Option D.
What is the right option? D is the none of the above, I know. But what should be the fact act would attract it here?
1985. Motor vehicle.
See, already Kolikonda, Sharad Babu already told in the first option he kept it. I changed it because I know that when MV Act is there, everybody will say that MV Act will not be touched. Then generally the next alternative is the Fatal Accident Act. So I removed the Fatal Accident Act and put the MV Act different year. And the right answer is that no doubt is that none of the above is the correct one. But the attracts is the Fatal Accident Act 1855 Is it clear?
Yes, sir. Yes, the fatal
See, we have to
accident.
make it some complicated because otherwise they can easily give the answer. If you write the Fatal Accident Act, any layman can give the answer. Is it clear?
Okay, sir.
That's why I changed it. So you read what I put on the screen.
Okay. Okay. The 24th question. The court of a chief judicial magistrate may be sentenced
No, may
otherwise
pass.
authorized by law. May pass any sentence authorized by law except a sentence A of death, B of imprisonment for life, C of imprisonment for a term exceeding 2 years, D all of the above.
D, all of the above.
I know it. Everybody will make it out. Sharad Babu has framed all of the above answer, but I changed it. If you happen to see the C, the imprisonment from term exceeding the 2 years, not 2 years, 7 years there. Then all of the above is the right answer. Is it clear?
Yes. Yes.
Then what would be the answer for the 24th question?
D.
C.
Oh, sorry. C is the answer.
Because if I write,
C is
because
the-
you read 7, you read, but I changed it to the 2. Because I know that people will definitely make it none of all of the above.
Yes, sir.
And it is stuck down. I don't know what I pressed.
No, 25th question.
Yeah, just a minute. Let me scroll. See, it is made somewhat. Okay, is it the same thing which I made it? Read the 22nd, but if you read that also, that is not useful to the students because they will always see the screen. Okay. Yes, now read.
25th question. Explanation is given under section 153 capital A of IPC for A. Weapons, B. Ammunition, C. Arms, D. Arms.
B,
There
ammunition.
are 4 options given. A is weapon, B is ammunition, C is arms, D is ALMS arms.
Sir, option A, weapons.
Option C is the correct answer.
Option C is
Arms.
the correct answer. Okay, let me take the lead from here. Yes, 26th question. Be ready. The CRPC 1973 repeals A. The Code of Criminal Procedure 1898, B. CRPC 1882, C. Option Regulating Act of 1773, D. Option Mohammedan Criminal Law.
Sir.
Option D.
Run.
Option B,
Option B, CRPC 1882.
1882.
The option is, the right option is A. The Code of Criminal Procedure 1898. I repeat, answer is A. The Code of Criminal Procedure 1898 is repealed by the CRPC in 1973. Is it clear?
Yes,
Say
sir.
yes. Is it clear?
Yes, sir.
Yes, sir.
See, unless you don't say yes, I cannot proceed it. Okay, let me read the first question because if it is goes up, it will not come down again. It is a problem. Yeah, if it is goes down, it's not come again because it's I think something is stuck out here. Okay, now let me read it. 27th question. IPC within parenthesis Indian Penal Code and CRPC within parenthesis Criminal Procedure Code were introduced in the year 1861, and these were codified by the Thomas Babington Macaulay, who was law member according to the Charter Act of Dash 1830, 1831, 1832, 1833. Which charter?
A, sir.
I know
Option C, sir.
if I write who has made the father of the IPC and CRPC mean definitely that you will make it the Babington Macaulay. But I changed it because I know that you definitely shoot it. Now you shoot it. 1830 charter, 1831 charter, 1832 charter, 1833 charter. Answer is
Option A.
1832.
1833
Option B,
charter.
1831.
Answer is
Option D.
Indeed.
D,
1833. Option
1833
D.
charter. 28th question. Anyone can unmute and read? Participants?
IPC and CRPC criminal procedure were introduced in
No murmuring. No murmuring. Loud voice.
IPC, Indian Penal Code, and CRPC, Criminal Procedure Code, were introduced in the year 1861. These laws were codified by Thomas Babington Macaulay, who was law member according to the Charter Act of 1833. These laws was introduced by Dash 1856 to 1861. Option A, Lord Jenkins. Option B, Lord Denning. Option C, Lord Atkinson. Option D, Lord Canning.
Option C, sir.
Option C, Lord Atkinson.
Wrong.
Sir, option A, sir, Lord
Option
Jenkins.
A, Lord Jenkins.
Sir, can option D.
Option B.
Yes.
Only option B.
Option D,
Lord.
Lord Canning. Later on, he introduced it in 1856 and 1861 region. You cannot get such a question in any book. It is I coined it.